Mr. Judicial Servant, I order you to register an FIR against the ACP. Pbal Pertap spoke these words directly to two Supreme Court justices. Justice KV Viswanathan asked for clarification. Are you giving us an order? The question hung in the air of the country's highest legal authority. Within seconds, case files were flying through the courtroom. Security personnel moved in, physically restraining the petitioner and removing him from the premises. Beyond the spectacle of a disrupted courtroom, we have to look at the psychological breaking point that leads a person to stop asking for justice and start demanding it from the bench. This confrontation tests the boundaries of legal decorum. It asks whether extreme frustration with the state gives a citizen the right to disregard the dignity of the court. The case is Pbal Pertap versus the State of Uttar Pradesh. Pertap was a petitioner in person, representing himself without a lawyer. His goal was simple. He wanted criminal charges filed against a senior police officer in Lucknow. He invoked Section 173(4) of the BNSS. This is a specific legal tool for citizens when a local officer in charge refuses to record their information. It creates a formal path to escalate the complaint. Instead of ordering the police to investigate, the court treated his application as a private complaint. This shifted the entire burden of proof from the state's investigators to Pertap's own shoulders. For a person seeking the power of a police investigation, this procedural shift feels like a dead end. The state essentially stepped back, leaving the citizen to gather evidence and present witnesses alone. There is a massive functional gap here. An FIR triggers the resources of the police department to find facts. A private complaint requires the citizen to act as their own detective before a magistrate. Disappointed by the lower court's direction, Pertap moved his battle to the Allahabad High Court. When he failed to get relief there, he escalated his case to the final authority, the Supreme Court. In any court, a personal belief in one's own grievance is not the same as legal proof. The bench cannot simply grant a demand because a petitioner is convinced they are right. The law operates on evidence, not desire. This was the moment Pertap lost control. He called the justices judicial servants, demanded they follow his orders, and hurled his case papers toward the bench. By failing to separate his personal anger from courtroom procedure, he transformed a legitimate legal grievance into a direct attack on the institution itself. The Supreme Court bench responded with silence. There was no argument, no shouting back, and no immediate move to punish him for contempt. The justices reviewed the record, found no legal reason to overturn the High Court's decision, and dismissed the petition. They followed the law, ignoring the noise. A petitioner may be driven by emotion, but courts are defined by their lack of it. The system must remain objective, moving only when the facts and the law align. Real systemic failures, like poverty, the reality of unemployment, and police apathy, create a genuine sense of despair in the public. This frustration is a documented reality of the modern legal struggle. But if a citizen believes that systemic failure justifies the degradation of the courtroom, the entire process of justice is compromised. Challenging the state is a constitutional right. Abusing the bench is a violation of the law. The system must not exhaust citizens to the point of breaking. At the same time, petitioners must keep their defiance within the bounds of the law, even when they choose to stand alone without a lawyer. Ultimately, a courtroom is moved by clear facts and reliable evidence, never by the volume of a person's voice.